acting as it should and must in a quasi-judicial capacity on these XYZ applications. But it's not acting impartially or independently due to its reliance on conflicted legal advice. It's required to be just as impartial as a court or jury, but the board has accepted and relied on legal advice provided by Drummond Woods, and that's Mr. Decker, and Christine Jones, which has been opposing XYZ in court. It would be as if any one of you sued me, had your own lawyer, and my lawyer was also the lawyer for the judge. It's a conflict, and it's been talked about for years in zoning manuals. This is just evidence from the city's recent production that Christine Fillmore is communicating and representing the city in connection with matters that related to an appeal, that Mr. Decker is providing advice to the board. He's counsel in the lawsuit between XYZ and the city that relates precisely to the same matters in front of this board. This isn't just a conflict, it's an obvious one. I'm not saying that you can never talk to city staff. There's lots of cases where there's nothing that's opposed, and I've been representing the MWRA, the Mass Turnpike Authority, the Convention Center. You know, there are informalities, but there comes a point where you start skating on thinner ice. It's like on Ockham Pond, going too far. There comes a point where that has to stop, and it stopped a long time ago in this case. There should not have been the city attorney providing advice to the planning board, and it was going on all the time. Christine walked out at the November 12th hearing with the board, and what have the courts said about this? They've said very clearly that this kind of thing is not permitted. It just presents insurmountable due process problems. Imagine how any of you would feel if you're attorney. This is from the Disqualification of Attorney Zoning Manual. I mean, there's nothing new in this world except the history we don't know. This has happened before. It was encountered recently in a case involving West Bath. The court noted that the fact the planning board's attorney also represented the town of West Bath created an obvious conflict of interest. And at the same time, pause on the screen share. It's a classic conflict because the assumption is it can only be inferred that the attorney assumed and intended from the outset that the board would act in favor of the attorney's other client, in this case, the city, and it has. You can't do that. A court generally defers, but this is a court in Maine, John Johansson v. City of Bath, saying a court can't permit a violation of a party's constitutional rights. The procedural and substantive due process rights were violated when the board permitted opponents of the application to help formulate the findings of fact. We've seen that too. Counsel writing findings of fact for the panel. Decisions from other jurisdictions are talked about in Maine. You know, I heard the argument made, well, gee, that's not New Hampshire law. New Hampshire, like Massachusetts, like every other state, looks to the law of other jurisdictions on issues like this. And here, it's a conflict of interest that has prejudiced XYZ. And we see it looking back 2 years. And there's still another equally serious problem, involving the board member, Mr. Founts. The statute's clear. It says no member of the planning board shall participate or sit on a hearing if they have a direct interest or if that person would be disqualified for any cause to act as a juror. I've done a lot of jury trial work, and I know about disqualification of jurors. We had an exchange, Mr. Founts. I mean, I'm left with this. This is an exchange back in November that Mr. Corwin had with you, Mr. Fauci, about drafting notes for a draft motion for consideration, and that was a motion to deny the extension. And what's down at the bottom here is testimony discussed during deliberations. That's testimony from the lawsuit in which Decker was representing the city, and we took a look at the expanded version of it, and this is the testimony that you included in your email, and a board member can't do that and not wind up having to recuse himself or herself. I mean, for example, in this part of the testimony you were citing, You mentioned basis for the board's decision. The testimony and evidence offered does not support the case that the circumstances, that's the conclusion that this panel reached. Every decision that this panel's reached in the last year and a half is tainted. It's questionable. Whether it applies in other cases, I don't know whether those applicants had adversity. I mean, you had legal counsel being the same, but in this case, we have a situation also where among the documents that have just been produced, I was produced 3,000 documents this weekend. Many of them were junk, which means I read 3,000 documents. And among them were this one. I mean, Mr. Fauci and Mr. Reichert are on a West Lebanon Revitalization Committee. Fine, they met in December, except that one of the items that was noted in the notes, and I think it says, Mr. Fauci, these were your memories, was that we've got to urgently investigate options to encourage or enforce site condition cleanup at River Park. Okay, fine. But then also investigate taking action as necessary to preclude the potential for sale, which it's an alternative development, which its zoning allows. Well, this is a private property owner who's appearing in front of the planning board. It's XYZ. They own the property. They have the right to sell it. And a member of the board, in fact, the chairman of the board, is participating in a group meeting where the idea is to take action to preclude the potential for sale, even though the zoning allows it. I mean, the procedure in these instances is that the board or panel takes a non-binding vote themselves as to whether someone recuses themselves. I'm just getting this information. Try to understand the position that it's my obligation to advocate as effectively as possible for the client that I have and to use the information that I have available to me as quickly as I can. And I haven't had a lot of chance to think about this. But this makes it look to me as if at least one member, Mr. Fauci, would have to recuse himself from a proper vote, and that as a practical matter, probably from other matters involving River Park, there have been cases on this issue. I mean, this is the New Hampshire provision, but there's case law on it. In New Hampshire, Winslow v. Town of Holderness, the planning board in this case was required by statute to notify all interested parties, and that's what you're doing. And I mean, there's no question this is a quasi-judicial proceeding, but this issue was the principal question that the New Hampshire Supreme Court dealt with, was whether the decision of a planning board is made invalid by the participation of a board member whose earlier remarks indicate he'd prejudged the case. In other words, does Mr. Fauci's vote have to have changed the result of the vote?
That does say before he became a board member, though. This was while he was a board member.
That one does, yes, but it doesn't exclude. We're not sophists after all. It doesn't exclude when it comes up after you're a board member. And in this case, they said, look, we've got to address the disqualification. You're supposed to be like a judge. A juror has to be disqualified. And the answer that they came with is, no, the entire decision's out, because we're not convinced that the one person who you're recusing didn't have an impact on the rest of you. And given the exchange that we saw in the emails that Mr. Fauci had with Mr. Corwin about it, I'm not saying people necessarily fully understood what they were doing. I don't know whether they did or didn't, but it's wrong. I mean, it's really wrong. And the conclusions are more or less the following. Mr. Clem's letter, it is what it is. And I'm not going to say any more about it. There's no need for me to say any more about it. It happened, but the past is prologue here. The building inspector's attempt to terminate the permit, that's bad. If I go back in front of the judge, I mean, he ordered the permit to be reinstated. It would only take 1 minute of explanation for me to tell him that somebody saying that this isn't the commencement of construction is contemptuous. They're just trying to end around your order. Or I could do an administrative appeal and get it set aside. Too many people have died in excavations and construction like that not to have people realize it's the start of construction, especially when the process for excavation was laid out in the building permit in 19. And people have had the building file. I've got emails saying that the building file was sent to Hayes. I don't know how he signed that letter, but whoever had him do it, or if he did it himself, I haven't seen the drafts, but I'll get them eventually. But he's wrong, and the premise seems to be, well, because you could have done a trench without a permit, that means that's crazy. Number one, you need a permit for excavation, as I've said. And then the planning board's reliance on conflicted information and improper ex parte communications with city officials have just tainted the prior decisions. I don't know to what extent it affects other cases. These are substantive due process issues, procedural due process issues. I mean, I was 20 years general counsel for a law firm of 100 lawyers in 3 cities. I had ethics and conflicts issues every day. This one wasn't even close. Once Mr. Decker and Ms. Fillmore were involved, their firm was involved in the litigation with XYZ. There's no way they should have been advising you. Not at all. But they did. And that's tainted everything that's happened. So we need time for reconsideration of the decisions. I mean, you can't tell me that this information doesn't. We can't tell ourselves that this information doesn't require a total reset. And for all of these reasons, XYZ's request, should be granted. And I mean, I'd like to have it granted now. I'm going to suggest get independent counsel. This planning board is entitled to and needs independent counsel, even before you make decisions on what I say, although I argue against myself. But, I'll invite questions, and I'll just conclude by saying you can assume that I know a great deal more about this overall situation, the city of Lebanon, than it may appear. I'm trying to help you. You just don't know it. Grant the extension. It's not going to hurt anybody. It gives us breathing room. I can't salvage a situation if I don't have time. That's why I came up here, off a plane. I'm exhausted. You're not catching me at my best. But think about it. Grant the extension for 2 years. Don't listen to the city staff. Don't act on the draft motion that you have in front of you, I'm sure, from Mr. Decker's office to say, well, gee, you really haven't done enough to procedurally even satisfy the burden you show to get us to even reconsider this. And don't even look at the other motion. Don't destroy them, file them away, because if I have to try this case, they're evidence. I know they're there. I've seen enough of them. So that's our presentation. That plus the letter that's behind it. And if I go into court on appealing planning board decisions, they'll be set aside in a heartbeat, and every single one of them over the last year will be voided.
Like that?
It doesn't take much to see this conflict. And my client has suffered, really suffered as a result of it. If you'd had independent counsel, if somebody had been providing independent counsel, it would have been different. I mean, I understand how these things go south. I've served on boards. All of us have. But this situation's out of control.
Okay.
Trying to get it back. So all that we're asking is that you grant. I understand, Mr. Burley. I understand what
I'm going to make a...
But I'm going to finish. I'm going to finish.
Okay.
We're asking that
I'm going to move that we extend... We're 7 minutes away from the meeting ending.
Oh, that's what you're doing. Okay, sorry.
I'm going to move that we extend...
Mr. Reichert and I aren't perfect. We each come up and... But whatever the reason...
Second.
Okay.
Yeah.
Can I get an all in favor?
If you have questions...
All in favor?
Excuse me. I'm sorry. I did not get what that was.
To extend the meeting to 10:15.
10:15.
Yes, thank
And who
you.
was the second?
Eric.
I'm sorry, who's?
Eric.
Thank you so.
Thank you. All in favor?
Okay. So I'll conclude just by saying there's ample, overwhelming evidence in the record sufficient to satisfy the procedural hurdle.